Hello, and welcome to today's presentation on releasing medical records, guidelines for reducing your risk. Presented by Gravitas Healthcare. Our goal today is to walk you through the key practices that will help healthcare providers manage medical record release requests while minimizing risk. If you have any questions, please feel free to reach out to us through our website, email, or phone. Let's take a quick look at today's agenda. We'll start with an introduction to common medical record release requests, followed by a review of the legal guidelines under HIPAA. Then, we'll dive into the types of record requests you may encounter, including health plan access and requests involving minors. We'll also touch on patient rights, special confidentiality laws, and some key risk management tips before wrapping up with best practices for handling these requests. Medical practices regularly receive requests to release patient records from various sources, including attorneys, law enforcement, and patients themselves. This process may seem straightforward, but it's essential to understand the complexities involved in complying with federal and state laws to avoid privacy violations. Today, we'll look at how to navigate these requests efficiently and safeguard patient privacy. The cornerstone of medical record release is compliance with the Health Insurance Portability and Accountability Act, or HIPAA, which was enacted in 1996. HIPAA, along with state-specific regulations like those in California, outlines how and when medical records can be released. Special protections are in place for sensitive patient information, and failure to adhere to these regulations can result in significant penalties. Let's explore some of the most common scenarios where you need to be cautious. There are several common types of requests for medical records. Attorney letters often indicate legal preparation on behalf of the patient, requiring a signed authorization before releasing records. Subpoena duces tecum, or court-ordered requests, must be thoroughly reviewed to ensure compliance. Similarly, workers' compensation subpoenas follow the same legal framework. Always verify these requests with proper documentation before releasing any information. In certain situations, federal privacy regulations under HIPAA allow you to disclose confidential medical information to health plans without patient authorization, typically for treatment, payment, or healthcare operations. However, patients have the right to restrict access if they pay for their treatment out of pocket, under the HIPAA Act. It's critical to ensure all patients sign a HIPAA Notice of Privacy Practices to understand these policies. Pediatric practices often face unique challenges when releasing medical records, especially in cases involving divorced or separated parents. Under most circumstances, both parents have the right to access their child's medical records unless a court order restricts it. Always request and review any legal documentation if one parent tries to limit the other's access. Under HIPAA, patients have the right to inspect and copy their medical records. This right extends to their legal representatives as well. Your practice should have clear procedures in place to handle patient requests, ensuring compliance with a privacy rule while maintaining efficient record management. Certain medical conditions, such as minors, HIV status, mental health, and substance abuse, require special confidentiality protections. These records cannot be disclosed without specific written consent from the patient. If you're unsure whether certain information can be released, consult with your legal team or professional liability carrier before proceeding. To minimize the risk of violations, always verify the legitimacy of medical record requests. Double-check that attorney letters are accompanied by patient authorizations, and review all subpoenas for proper documentation. If you're ever in doubt, don't hesitate to consult with your professional liability carrier. Having well-documented policies in place and training your staff on these processes will help mitigate risks. To summarize, compliance with HIPAA, state laws, and confidentiality requirements is essential to avoid violating patient privacy. By verifying requests, maintaining clear policies, and seeking guidance when needed, your practice can efficiently handle medical record release requests while minimizing risk. If you'd like more information or assistance, feel free to reach out to Gravitas Healthcare LLC. Thank you for your attention.